right, next up is Roger Martella.
Well, thank you. And David had asked me to address the legal issues surrounding the Clean Power Plan, which Steve indicated on his helpful chart represents about a third, maybe more than a third of the reductions that the president's counting on. And I'm going to basically focus today's 5 minutes on two fundamental questions: whether the Clean Power Plan is likely to survive judicial review. And the second, probably becoming the more important one actually, is when will we know whether the Clean Power Plan is going to survive judicial review. So I'm going to turn to those, but you might be saying in the first point, what's this lawyer doing up here, talking about a rule and whether it's going to survive in court when the president hasn't even finalized it, EPA hasn't finalized it. Shouldn't we give them a break and wait for the rule to be final before we're starting to speculate on whether or not it's going to even survive in the courts? And normally that would be a really good idea. We wouldn't want to get too far ahead of ourselves and start to prognosticate on whether something that hasn't even been finalized is going to survive judicial review. But this is kind of the exception for a whole lot of reasons. One being, the rule is going to be finalized relatively soon. I think we have pretty solid information at this point. It's going to be likely the first week of August. And while the administration is going to talk about a number of changes, perhaps many changes between the proposal and the final, we don't think that the fundamental structure of the Clean Power Plan is going to change from the proposal to the final. We're going to see this 4 building block system, 30% reduction. So the core legal arguments are not going to be fundamentally changed by the changes from the proposal to the final rule that we're anticipating. So given the importance of the rule, given the reliance the administration places on it, we do think it's fair to talk about the legal vulnerabilities and these two core questions: is whether it's going to survive judicial review and when we might know. I have handed out an article that I think are in your folders or is in the back desk that gets into more detail on the core legal issues. And so I won't go into detail on those. I want to kind of focus on these two core questions. And the first is being whether the Clean Power Plan, this essential element of the president's climate change reduction strategy, is going to survive judicial review. I won't go into details about the plan. I think everybody probably understands it at this point. This is focused on existing coal-fired power plants and a reduction that states are to achieve on average a 30% reduction of greenhouse gases between now and 2030, but beginning as soon as 2020. And I will say at the outset, in answering the question of whether, this is the rare case, perhaps even the unique case, where there's almost uniform consensus from those outside the agency that the likelihood of the rule surviving in its proposed or final form is very, very low. I don't think anyone is betting in favor of the rule surviving in its full form following judicial review. And I don't say that lightly, and I say that at the outset for those of you who are here from the embassies and focus on climate change largely. I want to emphasize that in the United States, the courts who will review the rule have demonstrated to us in the last 7-8 years or so that they view climate change as a top national priority for the United States. That the courts recognize that Congress is unlikely to act to take measures to reduce greenhouse gases on a domestic or international scale. And in the meantime, the courts look at climate change as a pressing issue. And a number of courts, the Supreme Court, the DC Circuit, the Ninth Circuit, have spoken in very strong language about the significant concerns they place on climate change. And as a result of that, the courts, we begin with the proposition, are likely to defer to EPA, are likely to defer to the states when they're taking action to reduce greenhouse gases. And that's exactly what we've seen in the history of the case law since 2007 or so. The folks promoting greenhouse gas reductions, the folks promoting climate change action, whether that's EPA or states or citizen groups, have by and large been successful because of the weight the courts are placing on addressing climate change. So we begin with that. We begin with that fact that that's not a level playing field, that EPA has a huge advantage to begin with. But we also have to recognize that the precedent of the Clean Power Plan and the approach that's being taken is something that's also going to weigh significantly on the court. And it's ultimately the precedent of what EPA is planning to do here that I and many other lawyers, not just myself, think are going to tip the scales against the rule surviving judicial review. And the precedent, we can talk about it at great length, but it boils down to one simple concept, that in the 45-year history of the Clean Air Act, it's been well established that what Congress intended and what EPA has done on every single occasion has set standards for facilities that are based on what can be achieved at that specific facility. That makes perfect sense, right? You're supposed to regulate facilities based on what they're capable of achieving. But EPA is taking a vast departure from that for the first time in 45 years. It says that it can only achieve a 6% reduction from coal-fired power plants, but it wants to get to 30. So to go from 6 to 30, what it has to do is look beyond what you can achieve at a specific facility and basically require states, commandeer states to regulate the entire energy infrastructure of their states. Natural gas, renewable, nuclear energy, and energy efficiency. And it's this precedent, this kind of stepping beyond what can be achieved at one facility, that ultimately is the precedent that we think is going to tip the scales with the court's concern in striking down the Clean Power Plan to some extent. And also the concern about, as Steve talked about, knowing that the president cannot achieve all these reductions from coal-fired power plants, the precedent on other sectors as well is if this authority is upheld for coal-fired power plants, what's going to be next? Portland cement, oil refineries, chemical manufacturers, car manufacturers. This will become a precedent by which all other sectors can be regulated in a way that no longer relates to what's technologically achievable at those facilities. So when EPA proposed the rule, I think in late May of last year, a number of things have happened since then that have only kind of reaffirmed the legal vulnerabilities of it. Just 4 or 5 days after EPA proposed the rule, the Supreme Court issued another decision involving greenhouse gases called UARG versus EPA. And in this decision, the Supreme Court said some language I'm sure sent a chill up EPA's spine. The court said, when an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy, we typically greet its announcement with a measure of skepticism. We expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. Now again, this language came out about 5 days after EPA released the proposed Clean Power Plan. And in another case involving a much more modest regulation of greenhouse gases, the court said EPA had gone too far, that it cannot use the Clean Air Act to regulate entire sectors of the economy. It's virtually unfathomable to see how these 5 Supreme Court justices would not find the same trouble, if not even greater caution, with the Clean Power Plan, which is orders of magnitude more expansive and more unprecedented than the tailoring rule that was addressed in that case. So that's been a further legal development that's only added to the legal vulnerabilities. But even recently, in the last few weeks, in the healthcare decision, King versus Burwell, we again saw the Supreme Court repeat this kind of theme that when an agency engages in a rulemaking of significant economic and political consequences, the court's going to look at that with an increased level of scrutiny. So we've seen the theme evolve over the last year or so, continue to evolve in the Supreme Court. That's going to probably factor in to the litigation and is unhelpful towards the defense of it, helpful for those who are addressing it. And even recently, even in the DC Circuit, and for those of you who may not be familiar with our litigation system, this case will be litigated in the DC Circuit. Even recently, the DC Circuit itself held that the Environmental Protection Agency in the last couple months held does not get deference when it's dealing with matters of energy policy, only environmental policy. The agency that gets deference when it comes to energy decisions is FERC. And that's something that the challengers have been arguing all along. So in addition to kind of the legal vulnerabilities that existed on the day of the proposal, there's been some significant developments in the Supreme Court and in the DC Circuit that have made the rule even more vulnerable. I have no doubt EPA will address these decisions in the final rule that comes out in August, but whether it's able to distinguish those sounds like something that's very hard to foresee. So that's the question of whether, and I want to briefly then impact the question of when. And the question of when is becoming a very interesting one because the president's obviously going to be talking about the Clean Power Plan in November and December when he's in Paris, and of course he's going to want to talk about a rule that's been finalized and still not been reversed by the DC Circuit. So there is a question about how soon the courts might look at this case. And what we typically find, if we were to challenge a rule today, it would typically take 4 years before we get a final decision from the Supreme Court, if the Supreme Court were to consider it. Probably 2 years to get through the first court, the DC Circuit, 4 years to get to the Supreme Court. So there'd be a significant amount of time before there was a final decision. But that's causing significant worries for the states and for the industries that are going to be subject to the regulation. The states have deadlines that kick in very quickly, as soon as 1 year after the rule is finalized, by which they have to make commitments on fundamentally how they're going to restructure their entire energy systems, which include a lot of political decisions, like how legislatures are going to pass new laws and new policies. And that is a very short period of time for something of this magnitude. The regulated industry is also going to be impacted by this immediately. Even though the rule doesn't technically kick into 2020, it impacts decisions that have to be made years ahead of time. So there's going to be harm caused to the industry sooner than that as well. And of course, the harm to the regulated industry has impacts on other sectors as well. The people who mine and transport the coal, the people who rely on electricity being reliable and affordable, and all these other sectors. So there's going to be a large number of both state and private parties that are going to be harmed sooner. So on the question of when, there's a number of different scenarios of when we may hear from the court. We could hear as early as the end of 2015. The court could decide to take up the issue sooner in the context of stay motions that are likely to be presented, and decide that it's going to issue a preliminary determination on whether EPA is likely to succeed or not in defending the rule. The next scenario would be a situation where we hear sometime in the middle of 2016. This would be the notion of the court saying that we think this case is so important that we should move it up on our docket and prioritize how we review it and expedite the review of it. And under an expedited review scenario, we could very well hear something mid to late 2016. And the government itself may have incentive for that scenario as well, given that it likely wants to see this rule defended in this administration and not in the next administration. Under the ordinary course, we might not see a decision until 2017, but to me that seems like the least likely probability. I think we're either going to hear something preliminary from the court by the end of this year or on an expedited basis by the middle of 2016. So that is kind of the legal summary and the legal vulnerabilities. And I know David has some follow-up on this, but again, there is this article that I left behind that has some more details on that. If I can answer any follow-up questions, please let me know.
Thanks, Roger. Really helpful. Derek?